Hi, and welcome to the Columbia Chamber of Commerce's weekly webinar. This program is being recorded and it will be available on the Chamber social media pages and on the Chamber's COVID-19 resource website located at columbiamochamber.com following this event. If you have not done so already, please mute your microphones so our guest speakers can be heard easily by everyone on the call. We'd also like to know who is joining us on the call today. So please type in the name of your business or organization into the meeting chat. And then lastly, if time allows, at the end of the webinar, we will take some questions via the meeting chat feature. If you have any questions, please type it into the chat box and we'll do our best to answer at the end of the webinar. Today we'll be discussing human resource issues and labor law that have recently been put into place by the Coronavirus Relief Package Phase 2. The Family's First Coronavirus Response Act. This phase has increased unemployment benefits and eased the requirements for keeping unemployment benefits, and included a refundable payroll tax credit for paid sick leave and family and medical leave wages paid to employees that are affected by COVID-19. Joining us on the call to give HR and legal perspectives on how this will affect your business now, currently, and as we come out of this pandemic are Keith Heckman, Human Resource Professional and Data Information Specialist with Columbia EDP Center, Inc., and Marjorie Lewis, Attorney and Partner with Harper, Evans, Wade, and Netemeyer. I'd like to thank both of you for taking time to be on this webinar this morning, and I want to make sure we have both Keith and Marjorie. Can y'all hear us?
Hi, yes, this is Marjorie.
Yep, I'm here.
Okay, thank y'all so much for being here. Again, for everyone attending, please make sure your microphone is muted throughout the duration of the webinar. If you have a question, please use the chat feature to submit it. Marjorie, I think we're starting with you this morning, and so would you please speak to some of the specific regulations that businesses need to be aware of, especially from the legal perspective?
Sure, I'm happy to do that. Hold on, I'm going to mute my other speaker. So we have as you're aware, under the Family's First Coronavirus Response Act, it went into effect on April 1st, and it has two components: an Emergency Paid Sick Leave Act and an Emergency Family and Medical Leave Expansion Act. What's gotten really confusing for everyone, though, is the interplay between those acts and also the state workers' compensation laws and benefits and the new Paycheck Protection Act. Other issues that have also come up, though, are, furlough versus layoff. And, now that we have these paid leave requirements, can people be, are you required to retain your employees, or can they be laid off? Can they be furloughed? What's the difference between a furlough and a layoff? Probably most everybody knows now that these acts cover private employers who employ fewer than 500 employees, and it counts full and part-time employees. There is now an exemption, though, that's been announced for employers with less than 50 employees, but that only applies to certain provisions of the act, and essentially that applies to the school and child care closure provisions. And it's not an automatic exemption. You do have to make sure, read the regulations. 29 CFR 826.40B has some detailed provisions about what you need to do to comply with that, the determinations you need to make, and and your record keeping requirements. There's also a component of this that applies to public employers. Generally, most of their requirements are going to be the same as to private employers. However, most federal employers are not. It doesn't apply to most federal employers. And I think another component of confusion has been that employers have thought, well, this applies to all of my employees. It does not apply to all employees. It only applies to the employees that are in the categories that are covered by the Emergency Paid Sick Leave Act or the Emergency Family and Medical Leave Expansion Act. Now, of course, when you have stay-at-home orders, that obviously broadens the impact of who's covered by these laws. So under the Emergency Paid Sick Leave Act, an employee must be unable to work. And that's the first thing that I really want to stress, is they actually have to be unable to work. And it has to be due to quarantine or isolation by government order due to COVID-19. They've been advised by a healthcare provider to self-quarantine due to COVID-19. They are experiencing symptoms and seeking a diagnosis, or they're caring for an individual who is quarantined or self-quarantined. And this has to be some individual with some relation to them. You can't just claim that for any individual. And finally, for an employee who's caring for their child if the school or daycare closes due to COVID-19. Under the Paid Sick Leave Act, they get up to 80 hours for a full-time employee, and part-time employees are also included, but they receive an equivalent number of hours that they would have worked. And there's a separate method of calculating benefits for part-time employees. And we have put up a screen just showing you the federal notice that's required to be posted that just briefly explains these rights so that you can follow along on this. The leave payment, though, is capped, and so it's $511 per day if it's due to the employee's COVID-19 absence, and it's $200 per day if it's due to the need to care for a family member. And those also have monetary cumulative caps. Under the Emergency Family and Medical Leave Expansion Act, and let me back up, the Sick Leave Act applies to all employees. There's no limit on or no requirement about how long you have to be employed. The Emergency Family and Medical Leave Expansion Act, though, applies to employees who have been employed at least 30 days. And everyone, I'm sure, is familiar with the Family and Medical Leave Act. Generally, you have to have at least 50 employees for this to apply. However, this has been expanded for the purpose of the Emergency Family Medical and Leave Act, so it will apply to employers with less than 50 employees. But the employee has to have been employed at least 30 days. And again, the employee must be unable to work. This category, though, of employee is more limited, and so it is someone who is unable to work because they must care for their child due to a COVID-19 related daycare or school closing. And this does give the employee up to 12 weeks of leave, and a portion of it is required to be paid. The first 10 days may consist of unpaid leave, although the employee can use the required 10 days of paid sick leave to fill in for that 10-day period. The employee can also use paid leave to substitute for any of this, because this leave is only paid at 2/3 of the employee's regular rate, so they could leave paid leave to make up for that difference. Again, it's limited to $200 per day or $10,000 total for the expanded family medical leave. Now, there are exclusions. In addition to what we talked about earlier, an employer can exclude an employee who's an emergency responder or healthcare provider from the sick leave and family medical leave provisions. And so for a while we were concerned about, who was a healthcare provider, because the act itself had a pretty limited and narrow view of who's a healthcare provider. That has now been greatly expanded, and in the regulations there's a definition, and that's at 29 CFR 826.30. It's also in the U.S. Department of Labor question and answer that's on their website, and I believe we have a link to their website in some of the PowerPoint presentation. But I won't go over all of the details of it, but suffice it to say that it includes a lot of employees who you wouldn't typically think of as being healthcare providers. But it does include anyone who is employed at a doctor's office, hospital, healthcare center, clinic, nursing facility, retirement facility, nursing home, healthcare provider, and similar institutions. Employees who are emergency responders can also be excluded. And again, the regulation has a pretty detailed description of who's an emergency provider. The Department of Labor does encourage employers, though, to be reasonable when using this exemption. A question that I've seen have come up frequently is, what kind of documentation can I request from my employee? The regulations have been issued that tell you specifically what documentation you can ask for, and they also say that you can't ask for anything else, and I think that's pretty important. I did notice that there for a while that the Department of Labor question and answer website did not match what was in the regulation, so you have to be careful to see what's in the regulation that tells you what you can ask for. Under 29 CFR 826.100, you can ask for any of the leave reasons. You can certainly ask for the name, obviously get your employee's name, who's asking for leave, the dates for which leave is requested, the reason for leave, a statement from the employee that he or she is unable to work because of the protected reason. And if they are going to, then you can get into specific questions about why they need the leave. For example, what's the name of the doctor or healthcare provider that is telling them that they should be in quarantine, or the identity of the order that's been issued by the government telling them to quarantine. You can ask questions about the child care provider or the school that is closed. But again, the questions need to be limited to what is in the regulation. You can also, though, ask questions that are required for the purpose of obtaining tax credits. A question that I've run into also is, can I furlough or lay off my employee, and what's the difference in a furlough or a layoff? So these are really just kind of common terms that people use interchangeably, but typically speaking, a layoff means the employee is terminated and you might hire them back, and usually they don't get any benefits or anything in the interim. A furlough is the employee is not working and they're not getting their salary or their pay, but they're still having benefits maintained. And so the regulations have clarified that despite the leave provisions, if you were going to close your business or lay off employees, or you don't have work, that you can do that, and you don't have to pay them leave under these acts if they are furloughed or laid off. They are, though, then eligible to apply for unemployment compensation. During leave, though, the employer, if they are taking leave and they're being paid for leave under this act, the employer does need to maintain any group health insurance benefits. As I mentioned, the payments that are made under these acts, the employer is entitled to federal tax credits for the leave payments. And if the tax credits are not sufficient to make up for the amount that the employer has paid, the employer is treated as if the employer made an overpayment on their taxes, and therefore they do get a refund. The Department of Labor question and answer website, and they have about 75 or 80 questions that you can go through and take a look at, but it is very detailed, and they talk about some of the questions that have come up are intermittent leave and whether or not the employer has to allow or can allow that. The general answer is that it's up to the employer to decide whether or not, they want to allow intermittent leave. And then also whether or not the person can use accrued paid leave. And generally the answer to that is the employer can, after the first 10 days, require that the employee use accrued paid leave. Well, why would an employer want to do that? The employer might prefer to do that so that you don't have someone who's off work for 12 weeks and then they come back and tell you, oh, well, guess what? Now I want to take another 4 weeks off using my paid leave, accrued paid leave that the employer provides. Another issue that you have to be really careful about is the treatment of exempt and non-exempt employees. Just keep in mind that although you may have the right to do something and it might not be, it might be allowed underneath the act as far as, how you're paying your employees and furloughing them and laying them off. But exempt employees, if you want to maintain their status as an exempt employee, for most categories of exempt employees, there are some this doesn't apply to. But you have to continue to treat them as exempt employees, which means that you can't dock them for an hour of pay or a half a day of pay. Generally, if they work at all in a work week, they need to be paid for the entire week. So I think those are the points I had, and I can let Keith take over, and then we can have questions.
Wonderful. Thank you, Marjorie. Appreciate the help there. Some great information, and as you saw, we'll be posting up some websites to go get the information that Marjorie was talking about, especially the Department of Labor website with that Q&A. So again, we want to remind everybody on if you have any questions, please type them into the meeting chat. We'll try to get to those at the end of this call. Next, I'd like to turn things over to Keith Heckman with Columbia EDP to discuss the impact that this act will have on human resources. What new policies should businesses be aware of? Keith, turn this over to you.
Thank you, and thanks again to Marjorie. I really appreciate having a lawyer here. That way you guys don't have to listen to me say I'm not a lawyer but 1,000 times. So I would like to mention some good news, and that is that the Department of Labor is currently doing a good faith effort for the first 30 days on this law. Luckily, the bad news is that's in 4/17 because it was 30 days from when it started. But that still gives us a little bit of time for getting our posters up and out. The other good news is that for remote clients, email is okay. Because in the past with some stuff, they've not always allowed email as a way to distribute, but with this one, they are. A frequently asked question I get a lot is, I've had to close my business. Do I still have to do any of this? And no, if you're closed, you don't have to worry about it. Now, when you reopen, then we'll have to go from there. I also was going to mention the Department of Labor question and answer. It's a huge, great resource. If you're not a big techie person, there's a trick of Control F, and then you can search through all that stuff because it has gotten really big. So probably no surprise, HR guy going to tell you, you should probably write some policies. I don't always say policy is the way to go, but with a law that is new, there's a lot of gray here, and it does allow for you to make some decisions. So this is the perfect thing to end up writing a policy on. One thing that you might not have thought about is to first start with a work at home policy, so that your employees know what's expected of them if they are one that works at home, especially since this law, a good portion of it, if they are able to work from home, that will exempt them from a lot from you having to pay these most of the time, not all. So that might be the best place to start, is get your work from home policy figured out, and how you're going to track what property of yours that they have or are using, what happens if it gets damaged, needs repair, replacement, who do they call, all this kind of stuff can put your employees more at ease if they know it in the beginning. So then obviously writing a policy more around these 2 leaves. Things to think about. Oh, I'm sorry, go back to working from home. Some of the things you might want to think about there too is what hours are they expected to be in the office? What hours are they expected to be remote? Also, how responsive are you expecting them to be? What kind of productivity levels are expected? If you don't have job descriptions, now might be a great time to start building those, because that would be very helpful there. Let's see. Oh, and with any policy, especially these sorts, we're going to want to put something along the lines of this is temporary. It's really, all policies is good to put some line in there that states we can change this at any time, blah, blah, blah. So regarding the leaves specifically, Marjorie talked about who is eligible, and so and those exemptions. So you may want to define what positions you feel are exempt. Some of those abilities for exemptions are based on the fact that that employee's skills, knowledge, and responsibilities, you can't run your business without them. And so it might be that you can define that right there. You may want to just put those, directly copy the potential exemptions straight into the policy from the Department of Labor, leaving you the flexibility to decide on the fly due to the fact that positions are probably changing a lot, who's having to do what. So that's an option, just things to think about there. When you are trying to define these positions that are going to be allowed and not allowed, you need to be careful of what I like to think of as accidental discrimination. The legal term is disparate impact. So you don't want to say this group, they can work from home and they're going to be able to do this and that, and then realize that that group is all men, and then the other group is almost all women. You can get yourself into trouble there. So you're going to have to be careful with that. Something that you might want to reiterate, it's in the law, but making sure people understand that they're really only able to do the Family Medical Leave Act if it's for a child and that they're unable to do any work at all. So if they are able to do work from home, even with a younger child or whatever, they might not qualify for this. Another thing to think about, Marjorie mentioned this as well, the intermittent leave. You do not have to do it, but if you want to, you might want to decide who's going to be able to do that. Be thinking about things such as the exempt versus non-exempt. Again, worrying about not accidentally discriminating against anyone. If you do decide to do intermittent leave, the Department of Labor is advising that if it's an on-site employee, that leave be done as a full day, where if they're off-site, you allow them to be able to take it in smaller increments. But again, that's going to be up to you and a discussion between you and your employees. I strongly recommend having a request form. You can make it very simple. again, pretty much copy the reasons right from the Department of Labor that they can take this leave, so that they check mark that and then sign off. So that way they're the ones who are stating that this leave will be able to get you your credits. And then, yes, if you can request any documentation, that's also going to help you keep your liability down. Oh, one of the other questions that I had seen was, if you already are over 50 and you are used to the Federal Medical Leave Act, does this expansion subtract from that same pool? And what I've seen is yes, that will subtract from the same pool of 12 weeks. If you're under 50, then you don't really have to worry about that so much. Then the next biggest thing is thinking about tracking and paying all of this stuff, and then making sure that you get your credits, right? If you have a payroll provider like we are, we have special codes that will get used, and I'm guessing that if you the other payroll providers most likely have these codes as well that you'll be able to use, track, and connect to your tax filings, so that with ours, it's a wash on the payroll automatically. You are already paying less Social Security based on how much you're paying in leave, which makes it a lot easier for employers. I think that's what so many of them, so many of the questions that I've been getting is that they're worried that they'll have to front this money and then get it later. It does seem as though it can at least be done to where it is a wash on your payroll. Other than that, I think that's really all I have. So I guess we can open it up for questions.
Keith, thank you so much. Appreciate the input. One of the questions that we've had, and we hear quite a bit, is the difference between exempt and non-exempt employees. That's changed through the years, and how that is. That's not just a salary versus a hourly employee. What is a good way, and this is for both of y'all, what is either one that want to answer, to determine your exempt versus non-exempt employees?
Well, this is Marjorie. Keith, I don't know if you want to go first or if you want me to.
Yeah, this is so tricky when you're not in person.
Yeah.
Go ahead.
Marjorie, go ahead.
Well, I think the way to do that is the Department of Labor website has fact sheets.
Okay.
And those are really helpful. And so if you think you have someone that meets the professional exemption, look at that Department of Labor professional exemption checklist. Make sure the person meets the salary component. They have to be paid a certain salary, and they have to be paid on a salary basis. They can't be paid on an hourly basis. And you can't, make a routine of, docking their pay because they went to a doctor's appointment or something like that.
Mm-hmm.
But really, I think you have to identify which exemption you think they fit into, and then look at that Department of Labor checklist. And then if you have a question about it, if you're a large employer and you have, for example, maintenance supervisors who you've been treating as exempt and you employ 50 of them, in that case, you really need to get an attorney opinion and do some research on that, because that could be a big problem if there's an error in how those people are categorized.
Good deal. Thank you. Keith, did you have anything to add to that one?
Not really. It's generally, I think one of the easier ways to think about this is when these were originally designed, if that person is getting paid to do a job and doesn't matter when and how, so it's almost like they're a 1099, but they work for you. That's when you start looking towards, okay, yeah, these might be exempt. Let's look at, those fact sheets are awesome. They are great. I love those. for really defining whether or not that position is. The other thing that I would strongly suggest is that if you think someone is exempt, then you find the fact sheet that relates with that position and you print that sucker out and you put it in there with their employee packet and state this position, not person, be careful there, this position is exempt and we feel it's because of this one.
Wonderful, thank you. Keith, you had talked earlier about the working remote guidelines, whether they be temporary, and if you don't have any, put those together. There's a lot of companies, I know we're included, we include ourselves in this, we now sent those out. But we've gotten a lot of questions. Well, I had to move so quickly with everything changing so fast. So we went from scaling down to all of a sudden sending everybody home. We haven't done those. Is it too late to send that out to our employees now that we've been working from home for, say, the last week?
Not at all. Matter of fact, you probably would have ended up changing them and sending out new ones anyway.
Okay.
You learn as you're changing, right? And it's all new territory for a lot of us. And so no, it's not a problem at all to send it out later.
Wonderful. And I'm not sure who this question might be better for, is with the self-employed individuals. Apparently that's been, things have been expanded out to our self-employed individuals. They want to know if they can apply for unemployment, has been one of the questions.
I'm gonna let you take that one. I think, Marjorie, I hear that I've seen that they can, but I'm not as well versed on that.
You know, I'm not as well versed on that component of it. I mean, I know that under the Paycheck Protection Act, self-employed individuals are covered by that. And I do believe that there's been an expansion of unemployment for that purpose also, but I'm not positive about that part of it.
Okay.
I do have one thing to add. Generally, so if you are paying yourself out of your company, paying yourself a salary, generally you can, because you've been paying unemployment taxes on you. So I see no reason why, if you shut your business down, I'm almost certain you can apply.
Okay. Wonderful. I believe, Marjorie, you spoke to this a little bit earlier. You know, there's a multitude of things that qualifying reasons of why people can take the emergency paid sick leaves, you know, self-quarantine, caring for someone with COVID, or childcare reasons. Does it matter? It can be one of those things, or do they have to have all those things for them to be able to use their emergency paid sick leave?
So the sick leave can be any one of those items.
Okay.
And the family leave, the expanded family leave, though, is only for, you know, taking care of your son or daughter as defined in the regulations.
Okay, thank you.
Actually, I had a quick question for Marjorie too. I had heard that they were not counting stay at home towards a quarantine. Have you heard the same thing?
You know, I actually checked the Department of Labor question and answer sheet before we started this, and it actually does say in that stay-at-home orders do count.
Okay, I have older information. Thank you.
Well, but I think that brings up a really good question, because if you look at, you know, like Columbia's stay-at-home order, there are a lot of exemptions to it. Now we have a statewide home, kind of what I've referred to as a stay-at-home advisory. And so you know, there's a lot of room, I think, for interpretation in who is really subject to a stay-at-home order right now. But yeah, but anyway, the question and answer sheet does indicate that a stay-at-home order does count as being a quarantine order. I wanted to make one clarification earlier on intermittent leave. When I was looking at the question and answer website, it does say, though, that you shouldn't allow intermittent leave for people that are actually staying home because they actually have, said that they've been exposed or, are under quarantine order for, under a doctor's direction, because the point of that original 10 days is to make sure that you're staying home and that you're not spreading the virus to your coworkers. So that, so basically that question and answer sheet was saying no intermittent leave for that first 10 days that's considered sick leave.
Wonderful. And speaking on that, the sick leave, can you just clarify and make sure that we're all on the same page? Another question. So you have the 10 days before you can go into taking the emergency leave. Does an employee, or is it optional? They need to first utilize their existing PTO and vacation, et cetera, they've accrued before they can use the emergency paid sick leave?
So my understanding from looking at all this is that the first 10 days, so if you're taking the expanded family medical leave, the Act actually says the first 10 days can be unpaid, but you also have the crossover with the Paid Sick Leave Act. So really your first 10 days you could use as paid sick leave. And the employer can, after that first 10 days, the employer can require that you use your accrued paid leave.
Okay, thank you. Another question to both of y'all, and this might be too new there might not be any interpretation out there because the interpretations change on a regular basis through this. With the new Paycheck Protection Program that went out, that opened last Friday, with that, part of that for the forgiveness part is you have to bring employees back on by June 30th, I believe it is, to be able to have part of that forgiven. Are there any regulations, laws that have been put out there, or anything that you can advise our members and our business community of and business owners of how you start bringing those people back on if you've laid them off?
The good news with some of this is that if it's been a short enough period of time, most benefits, a lot of times it's written into where 30 days, less than 30 days gone, you're able to pretty much slide them right back into benefits if you've done a full layoff and not just a furlough. You would need to go back through your hiring process. You want to make sure that you still have all the right documents on these, on everyone, W-4s. I think I saw that they are loosening some requirements on the I-9 to where they understand that with having to work remotely, you don't have to physically see the documents for right now. Although they're stating once this is over, then they're going to ask you to go see those documents and then sign it that you saw it. So yeah, it could be a little bit of an arduous process of getting everybody back on the books.
Okay. Marjorie, do you have any input on that?
I don't. I think those were good points. I mean, on that specifically, I don't have anything. I would just say that, as people are being brought back in, just confirm that they are able to work and can be brought back, that they don't, obviously, that they're not sick or have childcare issues or something of that nature.
Okay, thank you. Well, that's all the questions that we had for today and all the questions that we'd received. Keith and Marjorie, thank you again so much for your time today. I know you're very busy. I appreciate you taking time to give this information and pointers and help our business community as they go through these unprecedented times. I think everybody saw in there the list of websites. It sounds like probably one really good one for all of our businesses to go to is the Q&A with the U.S. Department of Labor. It tends to have a great deal, and thank you for the tip on how to do the search feature on that, Keith. Thank you to all that joined us today and taking time to do so. We understand how challenging and difficult these last few weeks have been to you both personally and professionally. Please know that everyone you heard from today, the Columbia Chamber of Commerce and all our community partners are here to help. Please follow us on Facebook, Instagram, Twitter, and LinkedIn for continued updates, as well as the COVID-19 resource page at columbiamochamber.com. Remember, we're recording this and we'll have it available shortly after the conclusion of this panel. Also be watching for more business assisting webinars coming soon. Thank you and stay safe, and we look forward to seeing everybody soon. Have a great day.